Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar, where we're going to be talking about the Pennsylvania Sunshine Act, or what is more commonly known as the Open Meetings Law. A couple preliminaries before we get started. First, let me say that this session is being recorded, and our recordings are a couple days afterwards. They get loaded up to our YouTube channel. And then there's a link that's placed on our website on the training page, excuse me, so that if you'd like to view the recording, you can go to our training page, click on the link, and there it is. It may prove useful for yourselves for future reference, or perhaps you have a colleague who couldn't make it this morning and they'd like to watch it, or maybe you're conducting some localized training. Feel free to use this video as a resource for that. If you've never attended one of these webinars before, they are basically a PowerPoint with me talking in the background. The PowerPoints also are available on our website, all of the PowerPoints that we use for training. Again, on the training tab, and same reasons. If you'd like to conduct localized training or for your own future reference, they're there. You can download them for free and just, do what you need to do. We view those as public records and are readily accessible to anyone who can use that information. During the presentation, if you have questions, you can type them into the chat feature, and I will do my best to answer them live. But there are a couple requirements, or a favor that I would ask you. First is that we are talking about the Sunshine Act, so let's stay on topic and limit our questions and comments to that. Second, if you can keep your questions as brief and succinct as possible, that always proves helpful. Occasionally, someone will type in several paragraphs, and it's just awkward for me to sit here and read through a lengthy question while everyone else is waiting patiently and quietly. So the shorter, the better. Now, if it looks like you have, a situation unique to your circumstances, or if your question is unusually complex, hey, we'll do one of two things. We'll wait until the end of the presentation. Oh, sorry about that. We'll wait until the end of the presentation and I'll come back to it, or we'll take the conversation offline. On the screen right now is contact information for the office. You can feel free to call in or go to our website, where you'll find some email accounts that you can use. And we have a crackerjack administrative staff who they intercept the messages, they answer the phones, and they will do their best to get you headed in the right direction. If it looks like it's something they can't necessarily respond to, then we'll escalate your inquiry up to senior staff. And we do our best to get back to you within 24 hours, because we realize if you're contacting us, chances are it's something that's time sensitive. So we're pretty good about that. So I would encourage you to contact our office really under any circumstances whenever you have a question. We can't answer responses, or we can't answer requests. We can't write requests on your behalf if you're a member of the public, and we can't talk about any active appeals that we may have before an appeals officer. But we'll still do our best to get you headed in the right direction with whatever dilemma you might have. Okay, so I think that takes care of all the preliminaries. Let's jump in here and start talking about the Pennsylvania Sunshine Act and why is it important. Well, I like to go to the act itself, and there's a kind of a preamble in it. And let me just cover this real quick. It's the right of the public to be present at all meetings of agencies and to witness the deliberation, policy formulation, decision-making of agencies. And it's vital to the democratic process, and that any secrecy in public affairs undermines the faith of the public in government and the public's effectiveness in fulfilling its role in a democratic society. Okay, very altruistic statement there. But when you take a look at it, it really is democracy in action. And, I'll just, give you a quick aside. I've been following a conversation in my township over the last week that involves the proposed sale of the public water and sewer system to a private entity. And this week, there has been two public meetings. One was pretty much informational, and then the second was a public meeting of the township supervisors where they had a discussion over the viability of this sale. Yeah, okay. But it just impressed me that, here is democracy in action because, there were people weighing in with, obvious concerns that they have. Neighboring townships have been through the process and, they had concerns where people were weighing into the conversation and, various Facebook pages and the like. And it just impressed me that, there was a meeting where they actually had they moved the meeting to accommodate a larger crowd, and even that facility wasn't large enough for all the people who showed up. Well, whether you're for or against the proposal is, a separate issue, but the fact that here are a series of public meetings where the citizenry, the taxpayers, have the opportunity to face down their elected officials and express their views really is unique to the American experience. And, I know that this sounds a little over the top, but I've traveled overseas and many countries do not afford this opportunity for people to say, no, don't do it, or yes, we support this. So the Sunshine Law in Pennsylvania really is critical to us as citizens and our opportunity to express our views, to view the discourse of our public officials who are making decisions on our behalf. And those decisions have an impact on our livelihood, on our, economic viability and the like. So this is an important law. And yes, I'm probably preaching to the choir here, but, I am, how can I say it, fully on board with the purpose of the law whenever an opportunity comes to strengthen that law or, point out potential abuse or whatever, I'm first in line. So it's a privilege to sit here and talk to you about this and let you know how this law works. So speaking of how it works, when we get an inquiry at the office, maybe someone will call in and they'll describe a situation and, they'll say, well, this is illegal, isn't it? Or, or a government entity will call in with a concern and say, okay, now, is this legal? Is this consistent with the law? There are three things we look for. And some of this is based on case law. Some of it is based on language in the law itself. One of the dilemmas with the Sunshine Act is that there really isn't a lot of case law available to provide guidance. So some of it, quite honestly, and you're going to hear this throughout the presentation, is guesswork. Educated guesses, but nevertheless guesswork until the courts have the opportunity to weigh in. But there are three things we look for when it comes to a public meeting and whether or not that meeting has been conducted in the spirit of the law. First is that there needs to be some form of advance notice to the public that the meeting is occurring, and then instructions on how to attend. And that can be more than just a physical location. Nowadays, with the internet and the advent of online communications, there is a component to many meetings where the public can view a meeting through the convenience of their computer screen. Then there needs to be the opportunity for the public to observe the deliberations. And deliberations is a specific word, so we're going to talk about what that means and how it impacts whether or not a meeting is considered legal or consistent with the requirements of the Sunshine Act. And then finally, there needs to be afforded the opportunity for the public to comment prior to actual decisions being made. And again, decisions has a specific definition. Decisions is basically a vote, where the public officials are deciding on the course of action that they're choosing to take as the result of deliberations, which involves discussions that could potentially lead to a decision. So those two words are linked critically when it comes to viewing the Open Meetings Law, or the Sunshine Act as it's more commonly known. Okay, so let's move on and let's answer the question, who is covered when it comes to the Sunshine Act? Because occasionally, well, it's actually more than occasionally, discussions will come up by an entity or by the public where there is disagreement on whether or not that public entity, or that entity in general, is covered by the Sunshine Act. And what the law says is that the Sunshine Act applies to any state or local government body and all committees. And notice we have committees italicized there. Now, there may be organizations that appear to be government entities, but aren't necessarily, that's not necessarily the case. For instance, if you happen to live in a condominium complex, the Board of Governors, that is a private entity, okay, not covered by the Sunshine Act. So their meetings could be private. And I'll talk about, stuff like fire companies and public libraries and the like, where the answer is it depends based on existing laws and case law. But anyway, this is what the law says. The Sunshine Act applies to any state or local government body and all committees that perform an essential government function. Okay, what does that mean, essential government function? Admittedly, it's somewhat subjective, but let's put an example on the table here. Let's say that within our township, the local girls softball team has won the state championship. Okay, quite an accomplishment. And the Board of Supervisors appoints an ad hoc committee that is going to be responsible for the celebration. We're going to have a parade, and then there's going to be some sort of recognition ceremony at the township park, okay, where we're going to celebrate the fact that the girls softball team won the state championship. Okay, now as significant as that accomplishment is, I think you can argue that having a parade and a recognition ceremony is not an essential government function. Okay, you're not going to find any statute that says you must have a parade, you must have, a barbecue. So I would argue that any gatherings of that ad hoc committee to plan the celebration don't rise to the level of a public meeting, because it's not concerning an essential government function. Now, if we switch this up a little bit, let's say that there's a standing committee in the township that on an annual basis reviews all statutes and ordinances to ensure that the language is up to date, that the ordinances themselves are still required and it makes sense and they're not in conflict with any new statutes, et cetera, et cetera. That, I think you could argue, is an essential government function, because it's important that our laws are relevant. And it's important that our laws aren't in conflict with each other. And you can find statutes that do require that ordinances be kept up to date and the language is relevant, et cetera, et cetera. Okay, so there, when there's a meeting or a gathering of that standing committee, you probably could argue that it's an essential government function and thus subject to the Sunshine Act. So yeah, it is subjective at times, and we have to sort it out, whether it be court action or reliance on legal jurisprudence or whatever, but usually there's a way to work it out. Okay, but it is a continuing issue where there's always new public entities being appointed and differences in opinion as to whether or not those entities are subject to the Sunshine Act or not. Ultimately, the court works it out. Okay. Questions popped up. Local EMS receives about 1/3 of its funding from municipalities, but there's no direct control of operations. Would they be covered? Mr. Lively, the answer is it depends. Okay. Currently, there's court language on fire companies, which could probably be extended to EMS, but EMS really, it's going to come down to the governance of the entity, the degree of control that is exercised by the local municipalities, and a couple other factors, one of which is the level of funding. Okay. However, I need to emphasize, just because an entity receives government funding, whether it be a line item or a grant or any other mechanism, even a tax abatement, does not automatically equate to that entity being covered by the Sunshine Act or the Right to Know law, for that matter. There are a lot of 501c3 organizations that rely on government funding to perform their functions, but that does not make them government entities. And we go back to this definition, a state or local government body. And in many cases, like EMS services are private entities that receive or rely on government funding, but nevertheless, they're still private, and thus their meetings are not open to the public. So I wish I could give you a definitive answer, but given current case law, the answer is it depends. Okay, and then the other factor is exercises authority to take official action. Okay, well, you would think, why wouldn't you have a committee that could take official action? And there are a couple examples where they do not. And I mentioned public libraries earlier. Well, maybe the better example here would be, I'll just give you a common example. And unfortunately, this exists in government where an issue comes up during a public meeting and there are strong opinions about it. Nobody really knows what to do. It's a no-win situation for a public official, whether they vote in favor or vote against. So in order to make the problem go away, they appoint a committee. Okay, but the committee doesn't have the authority to take official action. It's just, okay, you guys are in charge of this. Just, kind of go handle it. But, if there's any vote, we'll deal with that as public officials. The committee doesn't really have an authority. Or occasionally, they will appoint a committee as a fact-finding body. Okay, we have this issue that's before us. We don't have time to do all the research, so we're going to appoint a committee of staff, and we want you to go gather all the data and then come back to us. We don't want a recommendation, we just want information. Okay, so then we can make an informed decision and vote accordingly based on the information that you're providing. Okay, now that differs from the next factor that comes up, where the committee is making recommendations, because one of the things I recommend when it comes to trying to understand a law is, number one, read the law itself, but don't forget to read the definitions, because both with the Sunshine Act and the Right to Know law, if there's some vagueness in the language or there appears to be conflicting language or whatever, read the definitions, because a lot of times the definitions can shed light on where that lack of clarity is and provide a sense of direction. And sure enough, if we go to the Sunshine Act, there is a definition of official action. And within that definition is the term making recommendations. So if you have a committee that makes recommendations on a proposed course of action back to the main board, the elected officials, that is considered official action. Thus, the gatherings of that committee would be subject to the provisions of the Sunshine Act, meaning that their meetings have to be advertised. open to the public, the opportunity for public comment and the like. So while there is still some doubt and some disagreement as to whether or not committees should be subject to the Sunshine Act, this is what the law itself says. State or local government body performs an essential government function, exercises authority to take official action, and that official action could be as simple as coming back and making recommendations to the main board. Okay, now I mentioned case law and the lack thereof. It just so happens that with this particular issue, there is case law that has guided the Office of Open Records and municipalities and state government for several years. The case is known as Ristow versus Casey, and Casey would have been Governor Robert Casey back, several administrations ago. But looking at that decision and the language used by the Pennsylvania Commonwealth Court, I think it, elucidates further on some of the points that the law itself says. So let's talk about what Ristow has to say. First, these conditions kind of build on each other. Does the committee have decision-making authority? And there, it kind of goes back to what I was saying about the language in the law. You can have a committee that's appointed that hasn't been tasked with making decisions. It's purely fact-finding in nature. Okay, so if they gather to collect facts, those gatherings would not necessarily be subject to the Sunshine Act. Okay, then are the members appointed by the board, and are they authorized to act on its behalf? Okay, and I think this is an important one. You can have a committee that's appointed, that is self-appointed, okay? And here, I think the example of public libraries would be right on point. There are some public library boards that initially they were appointed by the municipality, or maybe they're coming together as a public library predated their relationship with the local municipality. So the municipality was not involved with appointing the library board. And then you have some where the model of governance is such that if there is a vacancy on the library board, the vacancies are self-appointed by the library board itself. The township board, the elected officials, or the borough or city or whatever, have no say in who the library board picks for the replacements on the board. They go out and do that themselves without any approval needed from the local municipality. Okay, so the board are not appointed by the elected officials. And, I don't want to paint with too broad a brush when it comes to public libraries because of the varying types of governance models that are used by public libraries. But there are those where the board is what we call self-appointing. And there is no authorization to act on behalf of the elected officials because the elected officials have not appointed the board members. I hope you see that distinction. Okay. And then we look at, this is the one I believe is the most critical. Are the recommendations made by members of the committee back to the elected officials pursuant to statute, ordinance, or some form of regulatory authority where the result is the enactment of laws, policies, or regulation? Okay, what does that mean? Well, let's go back to my example of the girls softball team celebration committee. Okay, they're going to come back to the elected officials with, we want a parade. The parade's going to be at 10 a.m. We've invited, these high school bands to show up, the local fire companies, and so. Okay, so they've made this recommendation back to the elected officials, but none of those recommendations can be based on statute, ordinance, or any form of regulatory authority. It's just what they think would be appropriate for a nice celebration. Okay, you're not going to find a statute on how you celebrate when your girls softball team wins the state championship. Okay, so therefore, they would not satisfy this requirement as written in this decision, Ristow versus Casey. Okay, because there is no regulatory authority that they could fall back on. Okay, so hopefully you see why that's a very important distinction. Now, all of this being said, all of this discussion that I've had, you still may be unsure. Is our committee covered? So my answer to that is, when in doubt, lean towards transparency. And there's two reasons why I say this. First is, I'm a consultant with the Pennsylvania Office of Open Records, okay, and I'm the preacher here. So we are the office responsible for government transparency. So of course we're going to say lean towards transparency, but that's based on experience. And a very pragmatic consideration here is that, what if you don't lean towards transparency? What if you decide, it's too inconvenient, we're not going to open up this gathering to public review? Well, it very well could be the case that someone then turns around and files a complaint against you and your organization. And we'll talk about enforcement here towards the end, but you could end up performing what I call the straight face test, which is where you need to stand before a judge and explain with a straight face why you didn't open up your meeting to the public. And if that judge disagrees, then you could find yourself and your organization subject to sanctions, okay, which could be very costly. And I would rather, if I were in your shoes, I would rather put up with the inconvenience of opening a meeting up to the public, as opposed to taking the risk of standing before a judge and explaining why we didn't open our meeting up to the public, and possibly having that judge disagree with me, okay, because of the fallout from that, which really could go beyond the sanctions when you consider the bad press, the potential for case law, et cetera, et cetera. Okay, it could be a very costly mistake that you're making, that I think if you embrace the policy of leaning towards transparency when in doubt, you could save yourself a lot of trouble and probably make a lot of friends in the process. Okay, so let's move on. And now let's answer the question, is it a meeting? Okay, and you can have gatherings that do not rise to the level of a meeting as defined by the Pennsylvania Sunshine Act. And we will occasionally get emails or phone calls. For instance, hey, I saw 3 of our borough council people having breakfast the other day. Isn't that illegal? They can't do that, can they? Well, it depends, okay? And we're going to talk about that. First offhand, we have to answer the question, is there a quorum present? How big is the board, and how many members equate to a quorum? Well, if it's an advertised gathering, you can have members phone in, because this question always comes up. Okay, let me think now. Under the Pennsylvania Borough Code and the First Class Township Code, there needs to be a quorum of the members physically present in order to hold a public meeting. Now, other municipal entities, you can have a member phone in order to meet the quorum. And by the way, if you have a quorum physically present, anyone in addition to the quorum can then phone in. Okay, however, when they phone in, it needs to be direct with no middleman per se. So something like, a Skype connection or Teams or Zoom, that's fine. Or, having a conference call with your conference device there is good. What you cannot do is have someone sitting at the table with a cell phone up to their ear, relaying back and forth what's being said. The communication must be direct, okay? So if that's how you meet your quorum, by having someone calling in, you're allowed to do that, okay? Then we need to answer the question, is there deliberation? Okay, question has popped up. If 3 members of a 5-member authority meet to interview a potential employee, is it considered a public meeting? Again, it's going to depend on the circumstances, but you might want to take a look at the exemptions for executive sessions when it comes to interviewing potential staff, okay? Because the exemptions may very well apply, and it doesn't matter if you have a quorum there or not. Now, this raises an important issue that I want to make sure everybody understands. When it comes to committees, it is a common misunderstanding that if there is a quorum of elected officials on the committee, that makes it a public meeting. If there's not a quorum, then we don't have to open it up to the public. Folks, you can have a committee with no elected officials on it, but if it meets the criteria that we just got done talking about, that is a public meeting. Okay, that gathering is a public meeting. I made no mention as to whether or not there would be a public official or a quorum of public officials on your committee. Like I said, you could have a committee with no elected officials on it, and they are still subject to the Sunshine Act based on the criteria that we covered in the previous slides. Okay, good question. Keep them coming, folks. All right, so then we have to answer the question, is there deliberation? Well, you go to the Sunshine Act, the definition section. Sure enough, there's a definition of deliberation. And it is any discussion regarding public business that could lead to a decision, okay? And it's could lead to a decision, not will lead to a decision. So if you have those 3 borough council people having breakfast, they can do that as long as they're not deliberating, talking about borough business, okay? They can talk about the weather, they can talk about their families, they can talk about, you know, whatever, as long as they're not talking about borough business. That's fine. Okay, and then we have to answer the question, is there decision making? Well, decision making is basically a vote or some sort of polling that leads to a particular course of action. You know, decision making at this level is official public action. And in order for that public action to be legal, there must be a vote taken. So if they sit around and decide on a course of action, that constitutes a vote, that constitutes a decision. And they can't do that outside of the public eye. Okay, if they then it's illegal. It's inconsistent with the Sunshine Act. So public officials need to be very careful. You know, if you want to get yourself in trouble with a judge, start making decisions in secret. Okay, and let's see what happens. All right. And finally, I want to caution public officials about what we call email meetings. Sometimes you have like a new board that's seated after an election. Maybe the person elected chair is from a business background, and they just think, you know, we could handle this a lot easier just with some emails, just like we do at work. Okay, so they start sending emails around, and maybe it's just individual emails to, you know, other council members or other township supervisors. Well, what happens is that starts a conversation, and before you know it, before you realize it, you are deliberating. And you cannot do that outside of the public eye. Okay, those email conversations, number one, they're subject to disclosure under the right to know law, but more importantly, for our purposes here, they are inconsistent with the requirements of the Sunshine Act because emails are not a public discussion that the public can weigh in on, and you're going to find yourselves getting in trouble. So be very cautious about that. Now, I need to put the exception here because there's always exceptions and exceptions to the exceptions. It is okay to have email discussions on administrative issues. Okay, well, what's that? Let's say that at a public meeting, the board votes on a particular course of action. Now that vote doesn't include any details, okay? That's what we work out later, okay? We've decided, for instance, we're going to spend $1 million on paving in the borough for this year, okay? But we haven't worked it out as to which streets, which intersections and the like are going to be paved, okay? So now we start an email discussion among the council members and maybe Public Works, whatever, to decide which streets are going to be paved. That is administrative, and that can be resolved through an email discussion, okay? Because the vote to approve the spending of the $1 million did take place in a public setting, okay? And all that was legal. Now we just need to figure out the details so we can do that part using an email meeting that is not necessarily open to the public, okay? So you need to make that distinction. Is it policy or is it administrative? And again, if it's a gray area that you're having some doubts about, lean towards transparency and save the discussion for a public meeting just to stay out of trouble, okay? What is not a meeting? Well, yeah, I just got done talking about an example here, administrative action versus agency business. Okay, then you can have work sessions. School boards, this is a common practice where they'll have their monthly business meeting, that's a public meeting, but then they'll also have a monthly work session. Now, a work session the communication is basically one way. It's information gathering. You may have the school board sitting there, and the superintendent stands up and gives updates on various projects, various initiatives, or brings forth information about meetings that they've been having about some new state mandate. Now, the board can ask questions of staff. Okay, you can have one-on-one discussion back and forth with staff. What you cannot have is discussion on the merits of the presentations among the board members, because that is deliberation. And remember, deliberation must occur in a public meeting. Okay, so the communication is one way. There's no deliberation among the board members, and there's no decision making. Okay, no votes are taken at work sessions. Now, I also want to caution having a work session that meets all the legal requirements of the Sunshine Act for a public meeting, but is still advertised as a work session. Maybe you can take a vote at what you're calling a work session because you've met all the requirements of the Sunshine Act, but you're still calling it a work session, which creates the expectation among the public that no decision-making will take place. It's, a great strategy for sneaking in a decision without having the public there. But again, there is this straight face test where you could find yourselves hauled up before a common pleas judge and explaining why did you take a vote when you were calling it a work session. And yeah, you may meet all the legal requirements, but then you have to look at the spirit of the law, and who knows how the judge is going to decide on this. So you can have gatherings that don't necessarily meet these requirements, and it's okay. Okay. Same way with conferences, retreats, all these requirements. What about a straw poll at a workshop? I would stay away from that myself. Okay. I cannot definitively say that that's illegal, but a straw poll represents kind of asking how someone will vote if this were conducted at a public meeting. Now, that vote needs to occur at a public session. A straw poll, I think you're on thin ice. I think legally you could probably pull it off, but it nevertheless, I think you're sticking your toe into the world of deliberation. The mere act of taking a straw poll means you're discussing the merits of whatever was presented at the workshop. So I would be very careful about that. And, if I were a judge, I'd be lifting an eyebrow right now. So yeah, that's a great question. I'm hesitant to give you a definitive answer, yes or no, but it just uh-oh. Um, I'm sorry, I just hit a button here by accident. Let me see if I can get the screen back. Oh gosh. Yeah. Okay, there we are. Not quite. There we are. Sorry about that. Okay. Yeah, it's a great question. I just would be very careful, and I'm leaning towards saying no, because the fact that you're taking a straw poll leads me to suspect you're talking about you're deliberating, and that's something you don't want to do during a workshop. Okay, good question. Yeah, that had me, smoke's coming out my ears right now. Okay. Um, all right, I think we covered this slide, and I'm talking a lot, so let's keep it moving here. All right, got to go back to this screen, et cetera, et cetera. There we go. Okay, public notice, the first leg of the stool here. Under the Sunshine Act, you're required to provide a minimum of 3 days advance notice for the first regular meeting of the board during that year, and typically it's a calendar year. Okay, and then what usually happens is when you publish that public notice, you also include the dates for all of the remaining meetings for the year. Okay, and it's typically it's a legal notice in a paid newspaper of general circulation. Okay, newspaper articles are what are known as puff pieces, don't count. It needs to be that legal notice. It needs to be in a paid newspaper. Those, free circulars that show up in our mailbox 3 times a week do not count. Okay, and just publishing it on your website doesn't count. The law currently says paid newspaper of general circulation. Now, I know that this is getting more and more difficult because of structural changes that are taking place in the news media business right now. But until the law is changed, this is what it says, so you need to follow it. Now, what if you have your organizational meeting and you decide that, we had been meeting on the first Tuesday of the month, but there's a conflict. We now need to meet on the second Tuesday a month. Well, then you would publish a second legal notice that has all the new dates, as long as it's at least 3 days in advance of the next regular public meeting. You'll be okay. And because of these structural changes in the news media, you need to account for, publishing deadlines, et cetera, et cetera. And if you have concerns about this, contact your legislator or your state senator and, express your concerns to them that this is becoming more and more of a problem. Why can't we use our websites? Why can't we use our Facebook pages? And you can. It's just that in addition to that, you need the published legal notice. Okay, and then you also need to have the dates published or posted at your meeting site. Okay, so that there's a physical notice where your public meetings are usually held. The law allows for special meetings. Let's say that an issue comes up where you cannot wait until the next regular monthly meeting. Well, you can have a special meeting. For special meetings, all the same requirements apply, but the deadline is now down to 24 hours advance notice as opposed to the 3 days for the regular public meetings. You can also have emergency meetings where you can bypass any requirements for public notification. However, you cannot create your own emergencies. Again, straight face test here. you must have a valid emergency in order to justify having a meeting without any public notice. I use the snowplow example. We're a small entity. We only have one snowplow for the entire municipality. That snowplow is old. It recently broke down. We can't get parts for it to fix it. The forecast says there's a storm coming. We need to buy a new snowplow now, okay, because of the storm. So you have an emergency meeting, everybody takes a vote. Okay, there's one sitting down on the lot where we need to go buy this snowplow. Let's do it. Okay, so that is a valid reason or valid scenario for having an emergency meeting. Okay, and then let's say you have a meeting scheduled, but you have to cancel. You know, maybe somebody is sick and you can't get a quorum together. There's no legal requirement for notification of a cancellation, but you should, here's a good example where you should, and I'm not saying shall, you should use your social media to get the word out that we're canceling the public meeting, okay? Because nothing is more frustrating for someone to come down to the Borough Hall, all the lights are out, the doors are locked, and there's nothing, no advance notice that you were canceling the meeting, okay? People get upset. All right, so if use what resources you have to get the message out that you're canceling your public meeting whenever you can. Okay, agendas. This is a fairly new addition to the Sunshine Act, so let me just cover this in case you're not familiar with it. All agencies must post an agenda. Confirming special meeting notice should also include all future meeting dates to be re-advertised. No, not necessarily. Special meeting does not require, there's no requirement for future meetings. Because hopefully you've done that when you had your organizational meeting and you advertised all the dates. I should say that advertising the dates of the remaining regular meetings is not a requirement. It's simply a common practice. Okay, so if you would happen to change the date of a regular meeting because of a scheduling conflict or something like that, that would have to be advertised if you had not done it already. Okay, but when you advertise a special meeting, as long as there's no change in dates to meetings that have already been advertised, you don't need to do it now. Okay, as long as you do it one time and stick to those dates, you're fine. All right, agendas. The agenda needs to cover all issues that you expect to deliberate or vote on at your public meeting. Okay, the agenda must be published for regular and special meetings. And then the question comes up, well, how detailed does our agenda need to be? It needs to be detailed enough so that a reasonable person can discern what it is you're going to be talking about. For instance, maybe on your agenda, it says discussion of new bond issue. Okay, I would argue that that's not enough. Rather, it needs to go into details of discussion on the new bond issue to refinance existing debt on the hydrant fund. Okay, we have a fund that we use, a rolling fund, to pay for new fire hydrants in the municipality. Okay, well, the opportunity has come up to refinance that debt because of lower interest rates, or what other reason. Okay, so we need to put at least enough detail in there so that someone reading our agenda has a reasonable idea what that new bond issue is going to be about. Okay. And I'll go into this. I think appropriate guidance is available through what's called the Reading Eagle case, and I'll go into detail on that when we're talking about executive sessions. But when we're talking about how detailed does the agenda need to be, that's what I use for guidance. What would a reasonable person need to understand what it is you're voting on? Okay, so the agenda is required for regular and special meetings. You do not need an agenda for work sessions, conferences, or executive sessions, which we'll be talking about here in a moment. And the agenda needs to be posted on your website, provided you have one. If you're using a Facebook page as your primary social media means, then it needs to be posted on your Facebook page. It also needs to be posted at your agency offices, the meeting site, plus you must have copies of the agenda available for the public at the meeting itself, okay? And then, what about changing the agenda? What if something comes up? Well, there's a timeline. So let me talk about the timeline here. 24 hours, okay? Anything in excess of 24 hours before the public meeting, you can change the agenda as you see fit if something new comes up, okay? It's fair game. Once you hit 24 hours, you can only change the agenda for what are called de minimis items, where there's no expenditure of funds as a result of the change or, what you're going to be voting on, or entering into a contract, okay? If you're going to enter into a contract, you cannot do that. You cannot change the agenda in that 24-hour window. Okay, so then we come up on when the meeting is actually adjourned or when it's called to order. Okay, so during the public meeting, if something comes up that you believe you need to change the agenda so that you can discuss it there at the public meeting, right then and there is a way to do that. And it involves 2 votes. Well, the potential for 2 votes. The first is that there needs, by majority vote, there needs to be a motion, second, and vote, just like you would any other order of business, to change the agenda, to amend the agenda. And it needs to be publicly announced why we need to change the agenda. Okay, so you do that, you go through that exercise. And you do this because then it becomes a matter of public record that's recorded in the minutes for this meeting, plus it's announced to the public. Then you can go about discussing the issue that you've amended the agenda for. And that may lead to deliberation and a vote, okay, which also becomes a matter of public record. It's recorded in the minutes for that public meeting, okay? Now, what if you don't take a vote on the issue that has been added to the agenda? That's okay, because you may decide after some deliberation not to do anything, okay? And that happens all the time, so that's fine. But you must take a vote in order to amend the agenda. Okay, now what if you amend the agenda and, how does that reflect on what you have there? Well, you need to post the amended agenda within 24 hours after the meeting has adjourned. And the same criteria apply with, your website, physically at your office and at the meeting site. Well, then the question comes up, how long does the posting need to be there? And it turns out, the law doesn't speak to that. There's nothing in the law. So then we come into, Ask George. Well, given that there is this commonality, this thread of 24-hour requirements before the meeting for agendas, I think logic would dictate that we use the same 24-hour standard after the meeting for amended agendas. Now, a caveat here. This is simply George's advice. It is not based on any language within the law or any existing case law, because there simply is none. Okay, I'm using the 24-hour standard by applying what I would call the common sense standard. At some point, this may be litigated, and a judge may say, well, George is full of it, okay? That's the best I can do at this point, okay? I'm just saying this based on this common thread within the Sunshine Act. A judge may agree, a judge may disagree, but people call, they ask for guidance. This is the guidance that we're providing, with that caveat that there is no case law to support this. Okay, I'm not providing you with legal advice here. All right, so I think that pretty much covers agenda. Let's keep it rolling here. All right, public comment. Okay, this is an important area of the Sunshine Act because this is where, the public gets to address their public officials face to face. Now, under the Sunshine Act, commenters can be limited to residents and taxpayers. Occasionally, you will have someone come in from out of jurisdiction, maybe a neighboring township, they sign up for public comment. The public officials have the right to say, no, we are only allowing this for residents and taxpayers. Okay, then they have the right to comment on issues that are or may be before the board before any pertinent vote takes place. That word may can be somewhat problematic because that kind of opens it up to the commenter to comment on anything that they want to. Even if it's not on the agenda for the evening, even if it's not something that the board was even considering. It may be some guy getting up and complaining about the potholes on the street when we're not talking about potholes tonight. Okay, but under this provision, under the fact that that word may is there, it kind of opens it up. Now, you can kind of address this. Okay, will the recording of this meeting be available? Yes, it will. I covered that at the beginning. Check out our website in a couple days and go to the training tab. Okay, so the board may establish reasonable rules for public comment. Typically, that's like time limits. Everybody gets 3 minutes, okay? But, under the rules that are used for public meetings, usually there's the provision that the board can set the rules aside. So, if there's something that comes up special tonight, the board, let's say you're following Robert's Rules of Order. Well, Robert's Rules has the provision to set the set the rules aside depending on the circumstances. So you can do that. So let's say for tonight, we're going to give everybody 5 minutes. Okay, that's fine. All right. Then there's the issue of spokespersons. Let's say something really critical has come up, that there's a lot of public interest. A group comes in, they all have the same t-shirts on, and they all sign up for public comment. Well, you realize if everybody, first off, and there's going to be a lot of repetition and you're going to be there all night. There is absolutely nothing preventing the chairperson going over to that group and saying, look, would you be willing to appoint a spokesperson? And rather than 3 minutes, we'll give them 10 minutes. So all of your points are covered. All right. And that way we won't be here all night and there won't be a lot of repetition. What do you say? Is everybody in agreement with this? And they agree? Yeah, you can do that. Okay. There's flexibility as long as it's clearly intended to meet the spirit of the Sunshine Act and ensure that the public has their day in, quote, their day in court, unquote. All right. And then I want to talk about a practice here. This is not a requirement of the law, but it's a practice where some municipalities are adopting 2 comment periods. One is specific for the issue at hand prior to the vote, and then the other is general that's used at the end of the night for those people that want to stand up and comment about the potholes on their street, okay? So what you will do is, you'll have an issue come up for deliberation, and prior to the vote, you then allow public comment on that issue. And then they go ahead with the vote or whatever. And then, like I said, at the end of the night, before the meeting is adjourned, there is a general comment period. Now, I want to emphasize, this is not a requirement of the law. It's simply a best practice that many municipalities are now adopting. Maybe you want to talk about it amongst your public officials, whatever, as a possible solution to, if you have a problem there. Okay, question has popped up. I work only 3 days a week. Question, if I am off the day after a meeting, is it not possible to post an updated agenda? It is not possible to post an updated agenda. Well, Ms. Kaiser, I can't really address that. I can only tell you what the law says. And if you don't post that agenda within 24 hours, you may be out of compliance with the act. Okay, now you're only out of compliance if someone complains about it. So, I think a lot of times reasonable heads prevail, but I would do what I could to comply with the act whenever possible. Okay, moving on from public comment. Executive sessions. Okay, I alluded to this earlier. An executive session is where a board can gather outside of the public eye in order to discuss sensitive issues. Okay. Now, an executive session can be held before, during, or after an actual open meeting, or it can be announced for some future time, okay, that we're going to meet outside of the public eye so that we can deliberate on a sensitive issue. But when you do that, you need to provide the complete reason as to why you're meeting an executive session. And here we go back to some case law of Reading Eagle versus the city of Reading. And what was happening is Reading City Council, when they would go into executive session, would say something like, we're meeting for personnel reasons, or we're meeting for legal reasons. The Reading Eagle, which is the local newspaper, took them to court. And they said, that's not good enough. We need more information. And the courts agreed. And if you read this decision, I'm going to paraphrase here, but it basically says you need to provide enough of a reason so that the public is satisfied it's a good reason for not discussing this in public. So, like, rather than saying for personnel reasons, you would say, you know, we have a potential disciplinary issue regarding one of our employees. We're going into executive session to determine whether or not the board should approve a suspension. Or we have a court case that's been filed, or, you know, a legal challenge that's been filed in the local court of common pleas against our township. We need to meet with our solicitor so that we can discuss legal strategy. The case is docketed as, you know, here's the docket number. Okay, that tells me that it's a bona fide reason for going into executive session outside of the public eye, so that I, as a member of the public, can no longer observe the deliberation of my public officials. I trust that they are giving me enough information for me to accept that. Okay, that's what the court says, the court decision. And that decision, like I said, it's called the Reading Eagle case. You can find a reference to it and a link to it on our website. Then no official action. Oh, yeah, minutes. There's no requirement that you have minutes for an executive session. If you do, there's an exemption within the right to know law that says they are not a public record. Okay, you cannot take official action during an executive session. Now, you can have a straw poll, as was mentioned earlier, because you can deliberate in an executive session. So you can take a straw poll, but the actual vote that makes it official action must occur in a public session. So you would have your executive session, you would have deliberation, you might take a straw poll. What do you guys think? Okay, but then you would need to adjourn the executive session, reconvene the public meeting, and that's where you take the actual vote that makes it official action for recording in your minutes. Okay. If you don't take the vote and rely on the straw poll, that's a violation. Or actually what's occurred is you legally could not take any action on whatever it is you decided because you didn't take a vote. Okay, so it doesn't represent official action on behalf of the board. That would be actually a violation of your city or township code. All right, moving on, we've got executive sessions too. Why can you take an executive session? What are the valid reasons? Well, personnel matters, hiring, firing, discipline. When it comes to personnel issues, it's actual positions or people, okay? It's not policy. So if you were going to meet to discuss a specific person's leave usage and possible violation of your leave policies, that would be a valid reason for executive session. However, if you were going to discuss leave policy in general that is not related to a specific position or not related to a specific employee, that would not be valid for executive session. That you would have to discuss in a public meeting. Okay, discussing labor negotiations, that you can do in private. Purchasing, leasing, or selling a property. The law does not say selling a property, but there is a Commonwealth Court decision, unpublished, that adds selling to the criteria. Consulting with counsel about litigation. Avoiding violating privilege or confidentiality. Okay, this would be attorney-client privilege, where your attorney wants to discuss an issue with you so that they can provide legal advice or legal guidance. Okay, you can do that in an executive session. Discussing university admission standards. I don't know, I wasn't around 50 years ago when this was added. Discussing emergency preparedness, like homeland security, evacuation plans, and the like. You can do that in executive sessions. Okay, violations. Yeah, I hinted at this earlier. Okay, now, during a meeting, the public can object to a perceived violation at any time. They can stand up and say, you know, Madam President, I believe you just violated the Sunshine Act through your failure to take a vote or not allowing public comment on this particular issue, whatever. And they are not out of order. Okay, now obviously it's done respectfully, you know, and it's an adult conversation. Okay, but they can stand up and say that. All right. Now, the agency can cure the violation. What if somebody stands up and says, hey, you know, I think you guys just violated the Sunshine Act? You can say, you know what, I think you're right. Okay, we need to go back and take a vote on this particular issue. You can cure the violation just like that, no harm, no foul, okay, during the meeting. Or, you know, maybe you can hold a special meeting and go back and do it the right way. Okay, you can do that. But what if the board disagrees? That's not a violation of the Sunshine Act. We're going to keep on going. Okay, well, then the person has the right, or a person has the right to, within 30 days, file a complaint with the appropriate court. If it's a local agency, you would go to your county court of common pleas to seek the appropriate legal relief. If it's a state agency, you go to Pennsylvania Commonwealth Court. And it depends on what you want to happen, okay? You can seek an injunction on any further action. You can seek declaratory relief. You can seek damages if you think it's appropriate. But that's going to be up to your court. Honestly, each county kind of has their own way of doing things. So we get calls, you know, I went down to the courthouse. They had no idea what I was talking about. Well, that's because there's just not a lot of case law on the Sunshine Act. But, you know, you need to be persistent. You need to figure out how it's done. How do you file a complaint with your local county court? Okay. If you believe that there is some sort of criminal culpability taking place, you can also go to your district attorney, and they will investigate the legal ramifications of any criminal or alleged criminal activity. They cannot rule on violations of the act itself because that is a civil matter. And then, you know, depending on what the judge decides, typically they hold a hearing, and this is where that straight face test comes in. They can, you know, they have broad leeway or latitude on what it is they can do if they determine that there has been a violation of the act. Okay, they can void meetings. This happened during COVID. There were some meetings held where they were online meetings, given the circumstances that COVID presented. There were issues with the computers and so forth, and you know the public was cut out of the process. Complaint was filed. The judge agreed. They voided the whole meeting. Okay, they can declare votes void. They can, you know, if they believe it's egregious enough, they can levy fines against the public officials. The first violation is $1,000. Second violation is $2,000. The fines are not paid by the agency. The fines are paid by the public officials. The agency cannot pay or reimburse the public officials. Okay, it comes out of your pocket. Okay, so this is why when I say err on the side of transparency, it's because it can get pretty expensive. Okay, so you want to be careful about alleged violations when it comes to the Sunshine Act if you're a public official. All right, some miscellaneous stuff. Oh, question has popped up here. If a work session is advertised, can council take a vote on a matter listed on the agenda? Well, Ms. Kaiser, that kind of goes back to what I was talking about earlier. If you advertise it as a work session, but then act like it's a public meeting, you are violating the spirit of the Sunshine Act because there is an expectation on the public's behalf that because it's advertised as a work session, you're not going to be taking a vote. So while you may be in compliance with the provisions of the Sunshine Act, because you've pre-advertised, you've allowed the public there, you've allowed public comment, you can take a vote and not be in violation. But my position would be, why didn't you just say it's a public meeting rather than a work session? Because if I read the paper and I see a legal notice for a work session, oh, they're not going to take any votes. Okay, so we don't have case law that speaks directly to this, but I'll tell you what, if I were a sitting judge and I heard all the facts and the fact that you advertise it as a work session, I would be raising my eyebrows right now. I would be very careful about what you're proposing, and I think you're on thin ice. But again, I am not providing legal advice here because there is no case law to support what I'm talking about. I'm just giving you my, how can I put this? My Joe Public opinion on this, okay? How I would view it. All right, okay. Again, another good question. We kind of covered that earlier, but I think, you know, you're raising it, so I want to emphasize my concerns over it. All right, some miscellaneous points here as we prepare to wrap up. Okay, any public meeting, you have to produce minutes, okay? In those minutes, record the attendance. What public officials were there, who voted for, and, you know, were the votes for or against. If there's a roll call vote, it needs to be specific to each public official, yay or nay. How did they vote? Okay, now the public can record meetings and they don't have to tell you they are doing it, okay? It is not a violation of the Sunshine Act or the Pennsylvania wiretap law, okay? That if I, prior to walking into a public meeting, take out my cell phone, put it on record, put it back in my pocket, and don't say boo about it, okay? I can do that. Now, if the agency is recording the meeting, you know, maybe they use it for purposes of producing the minutes, maybe they upload the recording to their website or whatever, they can do that. It's just that you need to remember, because that recording is in possession of the agency, it now becomes a public record accessible through the right to know law. Okay, what I recommend is prior to the meeting, when the chairperson is making announcements, they should say, there's no expectation of privacy. This is a public meeting. It can be recorded by any member of the public. And by the way, we're recording the meeting, okay? Just so that people understand that, because occasionally they will ask, you know, I want the recording turned off, or, you know, we've actually had solicitors stand up and say, I want the recording turned off so I can say something. No, you can't do that. There's no expectation of privacy during a public meeting. Okay. All righty. We are at the end of the presentation. So if you have any further questions, now's the time to get them in. In the meantime, I want to draw your attention to this website I've been referring to. If you've participated in other webcasts, other webcasts that we've been doing, you know what I'm about to say. This is the best government website you will ever see, okay? It is updated 6 days a week. with new information, Right to Know Law, Sunshine Act, decisions coming out of the Office of Open Records, court decisions, training opportunities on the website. There are guides for citizens. You're curious about the Sunshine Act even more? Well, go to our training page. There's also a page specifically for the Sunshine Act with FAQs listed, information on agendas that I went into in detail. If you're an agency open records officer, there's a 78-page guidebook that you can download. You want a copy of the Sunshine Act? It's on our website. You want a copy of the Right to Know Law? It's on our website. Download it for free. If you have questions, even if it's not about this training session, contact our office, okay? Emails, addresses, phone numbers, people you can call for information, and we'll get you steered in the right direction, okay? If you are a real geek about government transparency, subscribe to our Twitter feed, and every morning between 7 and 8 a.m., we will issue a tweet that will give you the news of the day on government transparency around the country, in Pennsylvania, and the like, okay? And we just want to encourage you to use the website as a resource. Reach out to us. If you have questions, please feel free to contact our office. When Ronald Reagan was elected president, or when he was running for president, I'm old enough to remember this. One of his campaign slogans that he used was, "What's the worst thing you could ever hear? I'm from the government and I'm here to help." Well, that's us, folks. Okay. Feel free to contact our office. We'll do our best to help you. All right. So I think we're at the end of the presentation here. There's no more questions. I'm going to prepare to sign off. I'd like to thank you for your participation here this morning, and I hope you all have a great rest of the week and enjoy your day. Take care, folks, and thanks a lot.